As influencers, we are navigating the world of influencer contracts, but we may not understand everything that goes into our contracts. In fact, there are a lot of clauses in most contracts that can trip us up a little bit, one of which is the indemnification clause. So, what exactly is this? How does it impact us? And what do we need to know about negotiating it? Let's jump in and talk to everybody's favorite entertainment and IP lawyer, Tony.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, TikTok, and YouTube account called the IP Professor that is dedicated to all things intellectual property.
And we've been talking a lot about how entrepreneurs and influencers can protect themselves inside of their businesses. One of the things that I really want to dig into is contract law for influencers. And specifically, I want to talk about the indemnification clauses because I know a lot of influencers who are very, very unclear on what this means and how it could actually impact them. So, can you break that down for us?
Yes, so indemnification clauses, which it's a mouthful right there, but the premise of an indemnification clause is essentially who are you going to shift liability to in the event of some type of claim arising from that contract. So, for example, if let's say I'm in the photo and video licensing space, and I work with a licensor who owns certain video content or photo content that I'm seeking to license. The contract may lay out certain language that says that in the event of any breach of this contract, um, either I would be liable as the licensee to indemnify any claims related to this contract on behalf of the licensor, or it could be the other way around. Kind of rare, but it could be the other way around where the licensor would indemnify me for any claims that arise out of any breach of contracts that I receive as the licensee. Sometimes there could be a dual indemnity where both parties indemnify one another. That's I think more common among bigger companies working with each other, especially if you're talking about media companies doing intra licensing, if you will.
Mm-hmm.
But one thing I'm going to mention is that when I talked about indemnification would be a shift of liability arising from any claims related to the contract. This is where it connects to something we've also talked about before in previous videos related to representation and warranty clauses. When you enter into a contract with any entity, and especially in the influencer market, it's going to be quite relevant. You represent and warrant certain assents that maybe if you're filming, let's say, an ad campaign series on behalf of Adobe or Samsonite or any of these other brands, right? You represent and warrant that you are the copyright owner of all the material that you're producing, that you didn't do anything that would violate any invasion of privacy, that you're not violating any trademarks, that if there were other people featured in a situation where consent was required, that you got all those necessary consents needed. The language of rep and warranty clauses is going to vary depending on the circumstance, the type of agreement, so on and so forth. But that is what's going to be the reason for the indemnification clause kicking in. So going back to the photo and video license agreement, if I worked with a licensor who claims to be the true copyright owner of video content that I'm licensing, and then Joe Schmo comes to me and says, hey, I'm actually the copyright owner, not the agency that you worked with. Now we have a conundrum. We have one party tell me that they were the copyright owner, and then we have somebody else tell me that they're the copyright owner. That requires me, the licensee, to now look at the agreement and say, what did I agree to? So we agreed to the licensor saying that they were the true copyright owner, and then I got to look down at the indemnification clause, which will typically contain language that says if there's any claim that arises out of that agreement, including any breach of contract or copyright infringement claims, which is what's happening between me and Joe Schmo, it could contain language that either says licensor shall indemnify licensee, me, for any claims related to that, or it could be the other way around, that I have to handle those claims. So that's also going to be really important, and that can only be amended or revised in the negotiation process. So I know that's like a mouthful, and I'll stop there, but I guess it's just important to stress, two main things. The language is really important in the indemnification clause, but also preceding language that connects to that indemnification clause is also vital, because it's basically a game of connecting the dots. It's it's going to be causal. One thing is going to be causal to the other. So it's indemnification clauses are going to rely on a lot of the other principal clauses above from pages 1 through 2 or 3 or 4, and so on and so forth.
That makes a lot of sense. And one of the questions I see come up a lot for influencers is if I am now handing over raw footage that I've created to a company and they do whatever with it, and now there's specific contract language that could place any potential issues onto the creator, they're very worried about how that might impact them if they then don't have that creative control. And now the language in the contract reflects on if someone comes after them, it goes to the creator. Can you speak to that?
Yes. So um, I think the main theme here is when you're even just entering the negotiation phase, you get a draft of the contract with the brand. The main question that you should be asking is, are my pockets deep enough? And that's relevant because in a hypothetical that KM is talking about, if my pockets aren't deep enough and I'm just handing the keys over to this brand and they're running with it with creative, where I lack creative control, and they use my content in a way that could be defamatory, could be detrimental to my reputation, or could cause some type of claim in any way, and the indemnification clause says KM is responsible, not the brand. Now that becomes a really big headache because, again, are her pockets going to be deep enough to handle a legal claim related to breach of contract, copyright infringement, defamation, so on and so forth? So it's so vital that, one, you're working with an attorney that can help redline those agreement terms. Two, you communicate with your attorney with what demands you're seeking. And three, the contract doesn't operate in a way, especially with influencers and brands, does not operate in a way that is going to be unilaterally beneficial to one party. It has to be there has to be a meeting of the minds. That's the policy argument with all contract law. You enter the bargaining table, you enter the bargaining table. When both of them are at the bargaining table, they share their sense, they share their pros and cons, but at the end of the day, that's the whole essence of that table. They put it there, they dump all of what they want. It's almost like when you're working with a puzzle, you scramble through all the pieces, and then you have a clear picture when it's all said and done. That is the essence of contract law. That is the essence of the meeting of the minds policy under contract law. So agreeing just from the get-go, just because the money is good with the contract, that's just not going to cut it. That's not a good excuse either. So having a lawyer working with you to lay out, this clause is going to be detrimental to you. What do you want, client? That's what your lawyer's going to ask you, and then you make certain asks, and just having that negotiation process with the brand is going to help create an even flow of communication. And you know what? More likely than not, the brand's going to respect you for making those ascents. I feel like some people get so tripped up and bent out of shape because they think the negotiation is going to endanger the agreement, and they're going to say, you know what, I don't want to do it anymore. Frankly, if that's how they feel, then they shouldn't have been in the business of soliciting influencer marketing or working with an influencer in the first place. The whole essence of a negotiation is to have that banter, that back and forth, ultimately with an agreement hopefully being made. And if you feel like you can't, you try and try and try and you can't meet those demands, then that's the cue to walk away. But
Right.
not from the get-go, oh, you're approaching us for with questions or red lines, oh no, we don't want to work with you. That's a very archaic, and I think even just a skewed sentiment to have, a skewed thought to have. So it bears importance. Just going, don't agree to the contract. Working with that lawyer and sharing your demands with the lawyer and them advocating for you, it's going to lead to a good outcome at the end of the day.
And I would even put forward that if you start to see people backing up because you ask for some small changes to make sure both parties are protected, that is a very big red flag and a company you probably shouldn't be working with, because what else might you end up dealing with, and what legal troubles could you potentially have if you do walk into that blindly? So we know that it's always important to make sure we are working with somebody who understands the law in a professional capacity, because you and I probably aren't going to get it, even if we do work with a lot of contracts and we have some pretty good ideas of what's going on. We don't know it all. So we want to make sure that you are getting connected with the proper lawyers for you and making sure that you take the proper steps to make sure you are protected inside of this industry. If you've got questions on working with contract law, go ahead and drop those down below for us. We want to make sure we're getting you protected in this, and you can always reach out to Tony on social media because he is daily dropping this really great knowledge and content to help us level up and keep protected on our social media, in our businesses, and in the entertainment side of what we are doing. Tony, where can everybody find you?
You can find me on Instagram, TikTok, and YouTube at the IP Professor. And on this topic of influencer marketing, I actually have a very good and rich network of influencer attorneys that I know personally. So if you have any questions related to that, or if you need a referral, I'm happy to help you. But in general, if you have any questions related to IP, I'm more than happy to answer them. You can always reach out to me in the DMs.
If you have more questions about some of the clauses that you're seeing in your contracts, drop the topics down below and we'll get Tony back for more episodes to make sure that we understand how we can best be talking to our lawyers to make sure that we know exactly what's going on inside of our contracts so that we are not being taken advantage of and have the ability to negotiate in a way that's going to serve both you and the company that you're working with. And we'll see you in upcoming episodes with Tony and in upcoming episodes that drop every single day, helping you navigate social media to save time and effort creating your content so you can make more money online and get back to running your business and living your best life. I'll see you in the next episode.